Hello, everybody. Morning. We were just waiting, just hanging on to get everybody into the lobby and through. So thank you very much. It's great to have you all with us this morning. So I'm Alison Smith. I'm CEO and lead consultant of Roots HR, and I'm joined by Jimmy Van Santen, who is Comply Services Manager and Consultant. And we're going to be taking you through this webinar this morning that's just an update on the Employment Rights Act. So for those of you who don't know us, we are Roots HR, a specialist HR consultancy for the social sector. We've been operating since 2009, and we're a social enterprise, and we provide high quality and affordable services to social sector organisations. As a social enterprise, we use our trading surpluses to provide free HR services to leaders and managers working in the social sector, as well as learning and development support under the Academy, Roots HR Academy umbrella. So our agenda today is we're going to go through the Employment Rights Act roadmap. We'll sort of focus on some changes that happened in February, what changes are happening in April, and also starting to bring you up to speed with changes that are coming into place in October of this year, and then also some likely changes in 2007. So yeah, it's an interesting time. I think this is the largest piece of employment legislation that we've had for quite some time. And yeah, changes are ahead. So we shall go through and talk through the Act. So the Act itself got royal assent towards the back end of 2025. So it moved from being the Employment Rights Act to the Employment Rights Bill to the Employment Rights Act. And it's now in implementation stage. And as we've said, we've got a roadmap of changes that are happening from now right the way through into 2027. There are some elements of the Act that will require further consultation with employers and may also be subject to secondary legislation. So some proposed changes may take some time to implement, and there will be secondary legislation that needs to go through Parliament to actually implement some of the changes. But we'll talk you through today what the roadmap looks like and where we're at as of 10th of March 2026. So having a quick look at the roadmap itself, looking forward from where we are now, there's quite a few changes coming through in April. We're going to go through all of these with you today. So we'll talk about some of the changes around collective redundancies, some new day one entitlements that will be coming in April, establishment of the Fair Work Agency and what we know so far, and some changes to statutory sick pay. We'll then look at some changes that are happening in October of this year, which include a ban on fire and rehire. And we'll obviously talk you through what we mean by fire and rehire, and the launch of a fair pay agreement negotiating body for adult social care. And again, some further changes that are happening in law to prevent sexual harassment, including sexual harassment from third parties. There are also some changes that are coming in 2027, includes things like mandatory gender pay gap and menopause action plans, enhanced rights for pregnant workers, but also there are a couple of the big parts of the legislation that are likely to be implemented in 2027. One is the day one unfair dismissal rights, which we will touch on today. We will go through today because there are some steps and actions that you're going to need to start taking over the next few months in relation to that. And also protections against zero-hour contract abuse. That's possibly the most complicated sort of part of the legislation, and I think will require significant kind of consultation, possibly secondary legislation. And there are still for many sort of employment law experts, there are still big question marks in their minds around what those changes might end up being and how they can be implemented. So we'll see what happens there. But what I want to touch on first of all is some changes that came in February of 2026. These were changes within the Act that mainly focus around trade unions, but there are some changes that are likely to be relevant to organisations within our sector. So the focus that I'm going to sort of touch on is around changes to compulsory recognition. So this is different to voluntary recognition. This is where there is a request from workers or trade unions for a compulsory trade union recognition agreement. And this will affect organisations who have 21 or more workers. When we talk about workers, we're not just talking about employees here. That will include casual workers and will include agency workers. So when thinking about would this be applicable to your organisation, you need to factor in casual and agency workers when looking at the size of your workforce. So this is relevant to compulsory recognition. And within compulsory recognition, we talk about bargaining units. And a bargaining unit is a group of workers in respect of whom the trade union is seeking to be recognised. So it doesn't have to be the entire workforce. It could be a specific function, department, team, in terms of the request for recognition. The current obligation is for trade unions to show that a majority of individuals within that particular bargaining unit would be in favour of trade union recognition, and that when a vote takes place, when there's a ballot around trade union recognition, that there's a requirement that the trade union has to win at least 40% of the entire business unit also has to vote in favour. So not only do they have to win the ballot, but at least 40% of the entire bargaining unit must have voted in favour. So that's the current law. That is being abolished. So there'll no longer be the sort of the barriers, if you like, around 40% of the establishment having to vote in favour. It will literally just be a majority win. There's also in the current legislation, there is practices that are called unfair practices that are not allowed and can be subject to penalty for the organisation if the Central Arbitration Committee finds in the trade union's favour. So if it finds that the employer has undertaken unfair practices. The unfair practices regime is going to be strengthened. And I'm not going to go into too much detail about how it's going to be strengthened, but basically the timescale where unfair practices can be alleged is broadened. And there is a requirement, a current requirement for any unfair practices to have had a material effect on the ballot outcome, and that material effect on the ballot outcome is a barrier that is going to be removed. What this means is that potentially a sort of one single, perhaps ill-judged comment by a manager, could in itself now be deemed as an unfair practice. And what that could mean is that the result of the ballot is effectively cancelled due to unfair practices, and trade union recognition is automatically imposed. So it's kind of strengthening the restrictions around unfair practices, which really means that, again, if you do end up in a situation where there is a call for compulsory trade union recognition within your workforce or within a bargaining unit of your workforce, that thinking about your managers and how they're communicating with people about this is going to end up being really important. There were also some other changes around trade unions that came in February as well, and that's specifically around industrial action. So dismissal for taking part in industrial action has become automatically unfair. The time needed to give notice of industrial action has reduced to 10 days from 14. So there's lots of changes, and sort of ballot notices around industrial actions were simplified as well. So changes in regards to trade unions have already happened, and that's particularly focused around industrial action, but also these changes to compulsory recognition. And as I say, that'll affect workers or organisations, sorry, who have 21 or more workers. So that's your employees, your casual workers, your agency workers. That won't include volunteers. I did spot a question coming up on that, but it won't include volunteers. So those are changes that came into place in February. Now, there are changes that will be happening in April, and these are the ones that we're going to go through now to kind of get you prepared for what's coming in next month. Firstly, I'll start off by saying that as happens every April, and this is not something that comes out of the Employment Rights Act changes, but it's just the statutory rates are reviewed annually and typically increase each April. So we've put details of the statutory payments and the increases from the current year to the new financial year. So from 6th of April 2026, the new rates. So for sort of family leave pay, so including things like maternity, adoption, there's an increase in the weekly pay to £194.32. That also includes is the same statutory rate that will apply for statutory parental bereavement and statutory neonatal care leave pay. Sick pay, the rate of SSP is increasing to £123.25 per week. There's some more changes on statutory sick pay that I'm going to come on to in a second. And the redundancy weekly cap, so this is a cap on a week's pay when it comes to calculations for statutory redundancy pay. As yet, we don't have the rate for next year. That's not unusual. Normally comes out sort of towards the end of March. So the current cap is at £719 a week. So we wait to see what will be the cap for 26-27, but that should come out within the next week or so. There are also national minimum wage rate changes that will come into effect, and we've got the rates here. The main rate, which is the 21 and over rate, national minimum wage will increase from £12.21 an hour to £12.71 an hour. We've still got the age bandings, but it is the aim of the government to reduce the number of age bandings in place. Important to note that this table is the national minimum wage, which includes the national living wage, that will be £12.71. It doesn't include the national voluntary living wage rate, which is set by the Voluntary Living Wage Foundation, which is typically at a higher level. So those are some of the statutory rates that are going to be changing. But we said that there are some other changes that are coming through the Employment Rights Act in April. And I'll start off by talking about some increased day one rights. So paternity leave and unpaid parental leave, so not shared parental leave, this is unpaid parental leave, will become day one rights. So employees who are looking to apply for either paternity leave or unpaid parental leave will no longer need a qualifying period of employment before they're able to take such leave. It's also going to be possible for employees who are looking to take paternity leave to take that after a period of shared parental leave. At the moment, the requirement is that paternity leave has to be taken first and then shared parental leave, but it will from April switch in the fact that paternity leave can be taken either before or after shared parental leave. So that's shared parental leave, not unpaid parental leave, just to make things confusing. So they will both become day one rights from April of this year. There are also coming changes to statutory sick pay. So a couple of big ones on this. The current waiting days rule, where SSP is paid after the third day of illness, is going to be abolished. So employees will be able to claim statutory sick pay from the very first day that they are sick. There is also the removal of what's known as the lower earnings limit. And this is a requirement for employees to earn a minimum amount to qualify for statutory sick pay. And again, that's going to be removed. So that means that there are likely millions more workers who are going to be eligible for statutory sick pay. That includes those who are on lower wages, who might have sort of part-time contracts, or they might have irregular hours. And for those individuals who previously earned below the LEL, which is the lower eligibility threshold, then for those who previously earned below that limit, their SSP will be, so their statutory sick pay will be the lower of either 80% of their normal weekly earnings or the set rate of SSP, which, as I said, is just going to increase from April. And when we talk about statutory sick pay, these costs, so all statutory sick pay costs, are met by the employer. So that means the cost of these changes, so where we now are paying statutory sick pay from day one, and where the no minimum weekly earnings are going to be required to be eligible for statutory sick pay, the cost of those changes will therefore be met by employers. So there is likely to be an increase in costs for employers from April in respect of statutory sick pay. So those are a couple of sort of larger changes that are coming. There's also some changes to whistleblowing. So from 6th of April, a disclosure that sexual harassment has occurred, is occurring, or is likely to occur will be explicitly protected under whistleblowing law. So at the moment, there are definitions of what are called qualifying disclosures, so disclosures that are actually covered by whistleblowing legislation. What's happening is from 6th of April, it will be explicitly set out that sexual harassment that has either occurred, is occurring, or is likely to occur is now a qualifying disclosure, which means that any individual raising such a concern will automatically be protected under whistleblowing legislation. We're waiting at the moment for some further regulations about this, which will clarify the date on which such disclosures need to be made to gain that protection. But we're waiting on that at the moment. There were several other proposals by the House of Lords that were made when the Employment Rights Bill, as it was sort of ping-ponging between the House of Commons and the House of Lords, but those were rejected by the government. But there are some further obligations on employers that are coming down the line in respect of prevention of sexual harassment. And we'll cover those off when we get to kind of autumn 2026 in this session. In respect of collective consultation for redundancy, there are current rules, and these will remain in place for collective consultation for redundancies taking place within a 90-day period. So currently, if you are planning to make redundant between 20 and 99 employees, then employers must consult for at least 30 days. If you're planning on making more than 100 or proposing to make more than 100 employees redundant, then employers must consult for a minimum of 90 days. And those requirements are not changing. What is changing is that employers who fail to comply with that collective consultation process. And if they fail to properly consult on collective redundancies, then they will risk a protective award of 180 days pay per affected employee. And that is increased from the current 90 days. And when we say per affected employee, that means if even only one employee made a claim to an employment tribunal, if it were determined that the organisation had failed to meet its consultation requirements or obligations for collective redundancy, then the up to 180 days pay would be awarded to every employee who was affected by that consultation process. So that's a doubling of the financial penalty for failing to comply. So it really does make looking at that sort of 90-day window, number of redundancies and consideration of establishments really important. So if you are considering any sort of restructures, redundancies, then I would always encourage you to take some specialist HR advice. We'll also see in April the introduction of a new statutory entitlement to bereaved partners' paternity leave. So this will apply when a mother or a primary adopter of a child dies within the first year after birth or adoption. The legislation will essentially provide the surviving partner with some protected time away from work to take on the child's care. Based on the draft legislation, it looks like this will be a statutory right to take a single period of up to 52 weeks of leave. This will be unpaid leave. And the leave can be taken at any point within 52 weeks of the child's birth or adoption placement. So within that first year. So when it happens within that first year. But we are, as I say, guidance on the protections during this period of leave that the individual will be entitled to take and are still to be published. We expect that they will probably be similar to other forms of family leave, so that the employment contract will continue and remain except for pay, that employees are likely to be able to have keeping in touch days and some protections around return to work. But as I say, we are waiting for the guidance to be published on those. But that's a new statutory entitlement that's coming in, which is bereaved partners' paternity leave. We'll then in April also see the introduction of the Fair Work Agency. This is a new government body that's been established to kind of bring together some powers to enforce employment rights across the UK. And it's going to be an executive agency within the Department for Business and Trade. And they are intending for this to be a single recognisable place where workers and employers can go for help, replacing sort of systems that currently might be undertaken by numerous different enforcement bodies. So the powers that the Fair Work Agency will have is a sort of what's been described as a single unified set of enforcement powers. So they'll be able to undertake and inspect workplaces, require employers to produce documents and evidence to essentially check the employer's compliance with employment law. And those powers are going to be similar to used by other existing enforcement bodies, which could be, say, the Health and Safety Executive. Where workers have been underpaid, for example, if there were minimum wage breaches, then the Fair Work Agency could issue a notice of underpayment, which basically would mean that the employer would have to pay workers what they're owed and also pay a financial benefit to the government. They are going to have the power to bring cases in the employment tribunal on a worker's behalf and provide legal advice and assistance to people potentially involved in civil cases if they apply to trade union law or employment law. For serious labour market abuses, they will also have some enforcement powers that are going to be based on pieces of legislation such as the Immigration Act. and they will also be able to recover enforcement costs from employers where action has been taken due to non-compliance. But what particular areas are the Fair Work Agency going to have these powers in? Initially, the Fair Work Agency is going to have powers and will look at enforcement around national minimum wage, around employment agency rules, around gangmaster licensing standards, and certain aspects of the Modern Slavery Act as well. Over time, it is also intended that the Fair Work Agency will also take on enforcement of holiday pay and statutory sick pay. So we do think that initially, probably the area that they'll have most impact in regard to any investigations or enforcements are likely going to be around national minimum wage concerns and potentially around employment agency rules. But then I think we'll see through time as they start to take on enforcement of holiday pay and also statutory sick pay. There is also in the legislation some flexibility for the government to later expand the Fair Work Agency's remit to cover additional employment law legislation. So those are a lot of the key changes that are happening or happened in February and also are happening in April. Our advice is obviously particularly to review and update policies where they may be affected. So thinking about things like sick pay, any policies around absence, thinking about introduction and changes, day one rights to paternity leave, unpaid parental leave, and also introduction of bereaved partners paternity leave. So thinking about things like family leave and policies. So yeah, and make sure that managers are aware of the changes as well. But then there are changes that are going to be coming down the line in autumn 2026 that we want to make you aware of. Again, you might want to start doing some preparation for. So I'm going to hand over to Jimmy, and Jimmy is going to take you through the changes coming from autumn 2026.
Fantastic. Well, thank you, Alison. So as Alison said, we're going to see some changes happening here in autumn of 2026. And we just think it's kind of good for you to understand what changes are happening. So as Alison said, you can start preparing where needed. So the first one I want to talk about is fire and rehire. And it's one of those kind of things that are slightly underrepresented in the news as one of the big changes, but it's kind of a major impact on organizations, specifically, I think, for organizations in the social sector, in charity sector, who rely on funding and grants. Because essentially what this means is, at the moment, if you want to make changes to people's terms and conditions, you go through a consultation period, hopefully you agree to the changes and we sign it into the contract and everyone's happy. But if an employee refuses to accept the changes, then you need to think about what you can do to essentially make the changes happen if you don't have any other choice available. And at the moment, what you could do in theory is you could end the existing contract by giving notice and then immediately rehire them on the new terms and conditions. And that's what's referred to as fire and rehire, because essentially we fired you on the existing contract and then we rehired you immediately on the new terms and conditions. Now, there's already a risk of unfair dismissal if someone has been with you for more than 2 years. Someone who's been there for less than 2 years cannot make that claim at the moment, because at the moment you need 2 years employment before you can make that claim. Now, in October, or at least in the autumn, the government is going to make that illegal. They're going to ban it. And so what they essentially said is, if fire and rehire happens, an employee can make an automatic unfair dismissal claim. And that means there is no need for a minimum service. People can just go to a tribunal and say, I've been unfairly dismissed because my employer made changes to my contract that I did not agree to. Now, there are also going to be some exceptions. So, for example, the government has said is, well, look, if you have financial hardship and you're at the verge of bankruptcy, essentially, and there's no other choice but to make changes in order to survive, then you can follow through with this practice. But of course, you need to be able to demonstrate that it was imminent bankruptcy or financial hardship that would lead to bankruptcy. And I can see there's challenges within that in our sector because, of course, a lot of organisations are working with restricted funding streams for particular services, and that funding stream might end or is reduced. And now all of a sudden you're going to have to make changes in that service, but you can't make the changes because it applies to the whole organisation when it comes to the financial hardship, not just to that service. And so we can still have conversations with staff about changing terms and conditions, but where a staff member does not agree going forward, we then have to start looking at potential redundancies if there are no other options available. There are two terms that we can change without having to seek agreement from the employee. One of them is about location. So if we need to move, for example, the office or the employees to work in another building, provided that's within a reasonable travel distance, we can make that change to the contract without the employee's complete agreement to it. And there was another one that just slipped my mind, Alison, if you can just remind me. Oh, duties. That's it. Duties of someone's role. So if obviously job descriptions, they do change over time and there might be some additional duties that we need to introduce, or we may remove some duties because they're no longer needed. That can still be changed as well, again, through some kind of forced enforcement of that change. Again, ideally, we always try to find agreement with the employee, but sometimes that might not always be possible. So autumn, that's going to be banned. We can no longer apply fire rehire. And if you do run the risk of an unfair dismissal claim. The next part is about harassment. Now, as you may have noticed, over the last few years, the government has been trying to strengthen the harassment legislation and is trying to put more onus on the employer to ensure harassment is prevented within the workplace. And specifically in 2024, we saw enhanced onus on the employer to prevent sexual harassment. And we, as Root HR, at the time, we created a toolkit for our subscribers to kind of download and take that into their policy kit, including some training material. Because essentially what the government wants us to do, they want us to make sure that we educate our staff on sexual harassment and make sure that people, A, understand it's not okay in the workplace. I mean, it's not okay at all, but obviously specifically we're talking about the workplace here, and how to recognize the signs of harassment and what people's duties are when they see harassment taking place, whether they're victims or whether they're witness to it, that they all have a duty to take action against that, whether that's going to your manager, whether as a manager you are looking into investigating the claim, and potentially even having to take formal action against the employee who is guilty of the harassment. Now, from autumn onwards, there's an additional kind of duty where employees are going to have to take reasonable steps to prevent harassment from third parties. That's from your suppliers, that's from your service users, your clients, partner organizations. You're going to have to take steps to demonstrate that you have tried to prevent sexual or harassment in general from third parties. You may have noticed when you go into the town centre now, almost every single shop is starting putting signs up that says basically, look, harassment is, we have a zero kind of tolerance policy on this. We do not accept abuse of our staff members. And we see that more and more kind of being placed in shop windows. I can fully foresee that whenever we're going to start working with other organizations, that we're going to see similar terms and conditions, perhaps in service level agreements, in contracts, and perhaps even ask people to sign it when they come in and use our services. I can also see where we might ask organizations that we're going to work with that we want to see their bullying and harassment policy to make sure that we understand what they do to educate their staff on bullying and harassment. Of course, it's going to be very difficult to fully prevent it, but again, you need to make sure you take all reasonable steps to prevent it. So that's something that we really are going to see being introduced in autumn of this year. The other thing we're going to see is that where you have non-disclosure agreements, so sometimes what happens is we see harassment taking place in the workplace, and we're trying to resolve it. It's very difficult often because, of course, the victim is hurt. They probably feel unsafe at this point. And although we might take action against the person who arrests, is that person actually able to come back into the workplace? And so sometimes what happens is we are offering that person settlement agreement to leave the organization. It protects the employer from any kind of future claims, and it allows the employee to leave with some money in their pocket and hopefully find a new job where they can move on. And often these kind of settlement agreements include an NDA, a non-disclosure agreement that essentially says you cannot talk about the reasons leading up to the settlement agreement or the settlement agreement itself. Well, again, from October onwards, that is simply not longer possible. We cannot silence people if they are harassed. We want to put it into a settlement agreement or some kind of non-disclosure agreement. We can no longer enforce that. So in other words, people are still able to talk about why they left the organization or why they may have left because of a settlement agreement, because we can no longer put it into an NDA to prevent them from talking about that. It's quite a big thing because essentially it means that these NDAs, even if they're being issued afterwards, are legally not enforceable, and therefore the employee can breach them quite easily if they're in place. And then the other change we're going to see in autumn is tribunal time limitations. So at the moment, if an employee is, for example, dismissed, they have 3 months plus 1 day to take a case to a tribunal. And they must do that within that time limit. Now, it can be extended slightly. If they, for example, go to ACAS and do early reconciliation, that will then pause the clock for a period, and that period is then added to the 3 months. So they get a bit of extra time to make the claim to the tribunal because they are trying to find ways to prevent tribunal in the first place. Now, in autumn of this year, we're going to see that time limitation being moved to 6 months. And so essentially means that employees have a 6-month window to make a claim against their employer from the date of the incident. So whether they were unfairly dismissed or whether it was a discrimination claim, they now have 6 months instead of 3 months to make a claim with the tribunal. And the pause would likely still remain in place if they were to go to ACAS. So if they go to ACAS, they still have that pause on the clock. So it can take a long time before you actually find out if the employee has made a claim against you, which is not great because it puts you in a bit of a difficult position. And also what it means is that you're going to have to hold on to data for a lot longer period, just in case the employee may have taken you to a tribunal. And so we really recommend that you start thinking about your retention periods, and if you have a retention policy, to kind of have a look at whether any of that periods in there are currently limited to 3 months or 4 months, and actually move that up to potentially 7 to 9 months, just to ensure that you keep data available in case an employee takes a case to a tribunal. Especially in cases where you know it's a bit contentious, where the dismissal or the resignation was not entirely clean. It's a good idea to keep that data available again in case of a tribunal claim, to make sure that you have access to data that you might need in your defense when a claim is being brought against you. So 6 months, quite a big thing. I don't think it's a very good thing, but because I think it just creates more uncertainty for the employer. And the employee, I'm not entirely sure why it needs 6 months to make a claim, but there we are. They've made that change nevertheless. Then we'll look at 2027, because we're going to see some really big changes happening in 2027 that will impact employment legislation in quite a significant way. And the first one that we all know is the unfair dismissal claims that an employee can make. So if we go back to kind of September last year, the government was still talking about making it a day one right for employees to essentially claim unfair dismissal. And then towards the end of last year, they changed their mind and made it now a 6-month period. So at the moment, if you want to make an unfair dismissal claim as an employee, you need 24 months of continuous employment with your employer. If you're dismissed before that, then in most cases you cannot make an unfair dismissal claim. You cannot go to a tribunal. It's kind of just tough. Now, there are multiple automatic unfair dismissal reasons. So, for example, if your dismissal was because of discrimination, or you were dismissed because you blew the whistle on your employer, or did any kind of other protected act, then you can take it already to a tribunal at any point within your employment. You don't need 2 years employment in order to do that. But those cases are quite limited, and it's not available for everyone for that reason. And so it kind of creates a situation where employees, in the majority of cases, are not protected within a 2-year window. So from 2027 onwards, in January, what we're going to see is essentially employees getting the right to make an unfair dismissal claim after 6 months of continuous employment with their employer. It's a much shorter period, and it's going to have all sorts of implications, which we'll talk about next slide, in terms of how you're going to do probation. Because at the moment, you have quite a large window to extend and delay or postpone probation meetings. But because of this legislation, we're going to have to really think about how we do probation effectively and how we are essentially making sure that we know whether the employee is going to stay or need to leave by the time we hit that 6 months. Because the moment they hit the 6 months, they're in protected employment. And then, of course, you need to make sure you follow all the correct processes to ensure that you're not taken to a tribunal. And if you are taken to a tribunal, that at least you can demonstrate you followed the correct processes. So 6 months of continued employment, employees can make an unfair dismissal claim. Now, what does that mean? It most likely means that employees starting from the 1st of July 2026, so in about 3 months' time, 4 months' time, will actually start and get protected employment the moment the 1st of January hits. And so really, it's going to impact your employees already starting from the 1st of July 2026. And so for that reason, we think it's a really important point in time to really start rethinking your probation processes. Because at the moment, we advise most clients that, probation should take about 6 months to complete, because, the first month, we all know it's quite hard to get into a job. You kind of get to learn the people that you're working with, the processes that you're working with, and then you kind of need a period of time to essentially see good performance and sustain performance as well, to make a decision on whether you want them to stay or whether they shouldn't stay in employment. And at the moment, we also see a lot more flexibility around extensions. So a lot of times we'll say, we'll extend your probation by a period of 3 months, because then we can introduce these kind of processes and make sure that you can really perform at the level that we need to perform. And then we'll make a decision at that point whether, you can stay in employment or whether you need to leave. And that's fine, because remember, they can't make an unfair dismissal claim for the first 2 years anyway. So even if we dismiss them after 9 months or even after 12 months, the risk of an unfair dismissal claim is relatively low unless it's for discriminatory reasons. But again, 2027, 6 months, they can make an unfair dismissal claim. So we really want to make sure that the whole probation period is contained within that 6-month window. And that means that we really have to start thinking about our processes and our policies and rethink that probation period length, because 6 months is now too long. If we wait till the very end of the 6 months, it takes one delay, one holiday, one sick leave, and all of a sudden the probation period tips into protected employment. And so we really want to make sure that we start thinking about moving our probation periods perhaps to 3 months, where at the 3-month point, we're essentially making an assessment on the employee's ability to work in that role. And then we can still tweak whether, if they are kind of working towards it, but just not made it, we can perhaps give them a month extension to the 5th month, but not much more than that, because if we extend it beyond that, we run the risk of them tipping into protected employment. And if an employee is not performing in the first few months, then of course, again, you would have to go through a full performance or capability process in order to deal with that underperformance once they hit that protected employment. And so we really want you to kind of think about that, of losing that probation period, also making sure you've got a good induction period within the first few weeks, if not the first month, where you really kind of bring up your employee up to speed in a bit of an accelerated way, where they are given time to learn the new processes, where they might need some support from other individuals to understand how you work as an organization, how departments might come together, where they can find their resources, but also if the employee, for example, is struggling with something, or is there any kind of support that we can offer to the employee so that we can test that support and make sure we can test whether that support is working for the employee in terms of how they perform in the role. as well as for people who are, for example, have disabilities and they need reasonable adjustments. Again, we want to make sure we can introduce those reasonable adjustments in time so that we can test and see if those reasonable adjustments are working within the probation period. Again, if you leave that too late, then again, it would all tip into protected employment, and then you are going to have to go through a much longer process. So we really want to encourage employers to start thinking about making sure your probation period process is solid, is robust, is within the time limit of the 6 months, to make sure that you are testing and seeking out what support the employee needs early on, and then make sure you implement that without any delay so you can actually test that support. And make sure you document every step of the way as well. We see it a lot where potentially probation periods are not very well documented, or managers don't take very detailed notes. And then when we get to the end of the probation periods, we're trying to kind of assess whether the employee should stay on or leave, but there's not enough documentation to kind of justify, for example, a dismissal or an extension to the probation. And so documentation is going to be key to this as well. And we really recommend you have a probation policy in place. Even if you're a small employer, it's a good thing to have a probation policy in place because it sets out the standards of a probation period. It sets out the expectation from the managers on what they need to do to prepare for a probation period. It also ensures consistency of the process. Because again, it's absolutely vital we keep things consistent so that it's fair to everyone who has to go through probation periods. So it's really worth kind of start thinking about that probation period. I think that's one of the biggest impacts as a result of the 6-month unfair dismissal option, is to kind of think about your probation periods and making sure that you can complete that within the 6-month period. Of course, and I should be quite clear about this, if someone has a disability and the reasonable adjustments take time to actually implement, we should not just cut it off at the 6 months and then tell the employee, tough luck, because of course then you could run into discrimination claims potentially if you didn't give the employee enough time to actually see if the reasonable adjustments were effective or not. So it's always be cautious on that. If an employee has a disability, that you don't just put a hard stop at the 6 months, but actually review if the employee is indeed improving in their performance. Did they give enough time to actually make sure the reasonable adjustments could take effect before you make any decision on a dismissal in that case. And then finally, I just want to quickly go over some 2027 changes that we might see, or will see in 2027 a bit later on. So we're going to see some increased pregnancy and maternity rights. There is still some kind of, or at least there was some consultation going on with the government where they were looking at enhancing dismissal protections for those who are pregnant or who are new mothers. So we might see something like that coming in. There's not a lot of detail at the moment on that, what they're going to do with it, but we do know they were consulting on that. And it's very likely we're going to see something coming in place in 2027. We're also going to see the implementation of statutory unpaid bereavement leave. So this will be available to everyone who would lose a special one. We don't know the full details of how far that might extend. We would imagine it extends only to the direct family. And it'll be an unpaid period of leave that people can take regardless of their length of service. We're also going to see 0 or low hour contract workers, and they will get access to guaranteed hours. Now, the way that's going to work, as far as we understand, is that over a reference period of 12 weeks, we need to average out their weekly working hours, and then we need to offer those weekly working hours to the employee as a kind of guaranteed hours. Now, the employee can refuse that. They can say, no, I don't want that. That's fine, but we must offer those guaranteed hours, and they can accept those hours if they choose to do so. Other protections that we might see are things like compensation for any kind of cancelled or changed shifts at a late notice. So if you are cancelling a shift, or you're changing a shift, or you're moving the shift to another day, and it's a late notice, and we don't know what late notice means at this point, then there will be some kind of form of compensation available to the employee. And we're also going to see the requirement to provide sufficient notice or reasonable notice to the employee about any shifts that they might have to work. So it's no longer a, come in tomorrow. There's going to be a period of time that the government is going to set out that they would require you to let the employee know when they are expected to come to work. Well, we're going to see increased requirement to notify employees why a flexible working request has been refused. The government is very hot at the moment on enhancing flexible working rights. Again, we don't exactly know what they're going to introduce on that, but what we do understand is that they are going to look at putting more and more onus on the employer to explain why a flexible working right request is not doable for the employer. And so we really have to start thinking about, if we are going to refuse a request, there are already 8 business reasons that we're limited to why we can refuse a request, but it probably is going to put a requirement in place that requires us to put a lot more detail into why we've chosen one of those reasons. We already recommend you do it anyway, just for clarity and transparency. It also avoids any kind of arguments from the employee, but that's probably going to be a statutory element to the existing legislation. And we're going to see further harassment changes. And in fact, the government is setting out what they mean by reasonable steps. So they're going to set out actually what reasonable steps are for an employer when it comes to avoiding or preventing sexual harassment in the workplace. And so we're going to see something come out in 2027, very likely in 2027, around what the government actually expects from employers when it comes to taking reasonable steps against harassment. So that is the remaining of 2027. That is us. We have 7 minutes left for any questions that have not been answered yet.
Lost my ability to unmute myself then. I think we have answered, or we're answering the majority of the questions as they're coming through, but there are probably a few that I'll just highlight that are in the chat, and some that have been asked via Q&A. So question are unpaid volunteers counted as workers? This was in the trade union recognition. No, they're not. It's agency workers and casual workers. Let's have a look. What else have we been asked? What does gangmaster mean? That's typically a role that's in agriculture, farming, so specific to that category. Do minimum wage rates come in on an employee's actual birthday? So for example, if they turned 18 or 21, so they would become entitled to the higher minimum hourly rate, but the new rate doesn't always apply on the exact birthday itself. It's from the start of the next pay reference period following the birthday. Is it an obligation on the employer to find out whether someone is eligible for SSP rather than an individual make a claim? Yes, it is. Let me just have a look. And then for tribunal time limits, could this relate to job applications or only people who are employed by the organisation? Thinking of time limits for keeping details of job applicants, yes, it will. So yes, we'd recommend that in your data protection protocols and documentation, you look at what your current document retention periods are for recruitment and selection, and whether you need to amend those. There's a couple of other changes that come in. Was the 0 hours guaranteed hours a definite change coming? No, it's proposed. There are changes that are proposed by the legislation, but this will certainly require consultation, and it will certainly require secondary legislation, and there are question marks from people already as to whether this will happen before the end of the current government. So we'll wait to see. We will wait to see. And then further question, did you say employers will have to offer the employee the average of their last 12 weeks hours on a rolling basis, or did I get that wrong? It is, Jimmy, I think it's right that it is the 12 weeks, the reference period for that, isn't it? That they're proposing.
At the moment, it's 12 weeks reference period, yeah.
Yeah, but as I say, it's all subject to further consultation and clarification. And somebody's asked, I haven't quite answered this one yet, how do we claim maternity pay? Is it deducted from NI payment directly, or does the employer have to claim themselves? I would suggest speak to your payroll provider or contact HMRC just for further guidance on that. And we might have, let me just check in Q&A. Question, would you recommend for policies to be updated prior to 6th of April? I mean, if they can be, yes. We always say, and we say this to our clients because we're working with clients at the moment around policies, a lot of the information from the government around these changes, some of it doesn't come out in a very timely fashion. Classic example there is the bereaved paternity leave entitlement that we're still waiting for clarification around that, entitlement and what that will mean for things like return to works and notifications. So it's not always possible to make the changes by the 6th of April. Where it is possible, where there's enough information, then if you have the time and opportunity, then yes, we would recommend you update policies. But where these are statutory changes, you're going to be obliged to implement the statutory changes anyway. So I think that's all the questions that we've got, unless anybody has any last minute questions before we finish. Thank you for the thanks that we're getting. We'll just hang on another few seconds just in case there are any other questions that are raised, but I think we've covered. So somebody's asked, as a CIC, are we able to reach out to your team to get some HR support with policies? Absolutely. Yes, our contact details are on the screen. So yeah, or go, have a look on our website. There's a contact us form on our website. And in case you haven't seen, in case you've not been on our website, there is so much free HR information and support on there. Toolkits, which is jam-packed full of documentation guidance. There are fact sheets, there's blogs, there's library of webinars, and if you haven't already, any social sector organisation in the UK can access up to a free hour of HR consultancy from us. Will we be putting on more webinars in the future? Absolutely, we will. And so they are always sort of publicised on our events and offers page on our website, and we typically send out emails to people who are on our mailing list as well, just letting them know of webinars coming up. So yes, we will publicise any webinars. Okay. So I think that's everything. So thank you very much to everybody for attending today. I hope that's been really helpful for everybody. And yeah, I'll ask a colleague to send out a copy of the slides. I know that was asked for, so we'll send out a copy of the slides, and we will have a copy of the recording of the webinar up on the website as well. So if you need to rewatch and just refresh yourself with anything, that will be available on the website too. So thanks everybody for your time today. I hope that's been helpful, and we look forward to seeing you again soon. Thank you. Bye.